Leo, how are you?
I'm well. How are you, Maya?
I'm fine, thank you. It's honestly, I've known you for years now, and I can't believe it's my first time interviewing you. You're a very well known and a very good lawyer in Ottawa. You're one of the top lawyers right now in the Ottawa area, in the East area, and I can't believe it's the first time. But welcome to Lawbreak, Leo.
Better late than never, Maya. Thank you
I
for having me.
I agree. Well, it's very nice to see you and to talk to you today about something that, well, I think you have tons of experience doing projects. This is what we want to talk about because honestly, I think in Ottawa, there's not a single project that happens without your name being involved in it in some way, not as an accused, but as the lawyer, one of the many lawyers who are on these cases. So you do a lot of these cases. You do a lot of drug cases and murder cases and other types of cases. But this is one of the types of cases that we see you a lot in the East region. And I wanted to talk to you about this because it's a bit of a complex type of case, the project cases. So there's a lot that we want to cover. I'll start by a very dumb question, but why are they even called project cases, Leo?
Well, I think it just kind of it's for these expansive investigations that the police embark on that doesn't necessarily target one particular individual,
Hmm.
and usually leads to arrests of multiple people. And so, because it's an expansive investigation, they like to give it a fancy name. That's the best explanation I can come up with.
Right. And the name is not necessarily connected to anything, right? In the case.
Not necessarily, though sometimes I wonder if it's an inside joke or an inside
Okay.
kind of thing amongst the officers involved. I'm not
Yeah.
sure.
Yeah. All right. Well, so one of the things and the challenges in these cases is that, as you mentioned, there are a lot of people involved. There can be up to 20 or sometimes more than that co-accused, which means that there's also massive disclosure. So the first issue here in these cases is how do you go through all this disclosure? And we're talking here about thousands, sometimes tens of thousands of pages and videos and photos. What do we do
It's a
when it?
pain. It's a huge
Yeah.
pain. I low key, I hate projects.
Mhm, okay.
But a traffic stop, warrantless search any day over a project
Yeah.
case.
Yeah.
Um, they are immensely difficult to navigate, not only because of the volume of the disclosure, but often
Hmm.
you're dealing with, you gotta download this specific program in order to access these videos or intercepts, and so it's a huge pain, and it's important. So as a first order of business, it's important to just get on top of the disclosure and to organize it as best as you can. As sort of we move into a more and more paperless era,
Yeah.
I find that I organize things electronically, and so depending on how you get the disclosure, because we often get things either on a hard drive or a USB, or on the cloud. But I always in projects dedicate my own external hard drive to a project, and that is where I keep everything. So everything that comes in goes onto that hard drive, and at first I just organize it by way of the date that it comes in. So it all goes into, if I get disclosure today, it goes into a folder that's
Like
titled
today's date.
March
Yeah.
19th, 2026 disclosure. And then as I move forward, you got to make sure you have a hard drive with enough capacity. But
Yeah.
as I move forward, then I start duplicating it into other subfolders. So I'll have a subfolder of witnesses, and then divided by police witnesses, civilian witnesses. Now in projects, you're getting way more police witnesses than
Hmm.
civilians, but then I
Yeah.
break down the police officers by last name, and then everything authored by that police officer, or everything that they happen to be in if they're in a surveillance report, which requires duplication, then I put that document in under that police officer's name. And then I'll even have a subfolder of surveillance reports, which duplicates all the surveillance reports. The idea is to be able to navigate that disclosure. One of the annoying things about projects, I find, we're dealing mostly with the federal crowns on these kinds
Hmm.
of
Yes.
projects, at least in the
Yeah.
eastern region, is that it just seems like the federal crown is dedicated solely to this project,
Hmm.
and they don't seem to have that many other prosecutions, whereas you as defense counsel, you're trying to, like, juggle all sorts of other matters that you have, new clients coming in, of course, administering your firm
Practice.
or
Yeah.
whatever it is you're doing, your practice, and you just feel totally outgunned, right? And on top of that, the federal crown has a dedicated disclosure clerk, that
Hmm.
they organize things on their end in a different way than how they give it to you. So it
Yeah.
feels like you're at an immense disadvantage, and it's
Yeah.
important to try to make up some of the ground there, because I like to use student interns, students that get credit, or also like juniors, if that's something that you do have in your office. I realize not everyone has that luxury, but it is, I think, a good opportunity for junior lawyers to assist, or students to assist in helping you organize the disclosure. Very often, you have ITOs, if not in all cases, you have ITOs. And one of the first things I do is, once I receive the ITOs, is I have them all separated and organized chronologically. And one of my first sort of exercises of marathon disclosure review is start with ITO number one, tracking warrant. How did this investigation start? And if I have enough time, I'll even build my own timeline in like a Word document where I just have dates and what
Where you
occurred on
list
that
all
date.
the ITOs
Yeah.
and
And that goes
chronological.
for every case, to be
Yeah.
honest. I try to build a timeline. I'm not always, I don't always meet that goal, but I find that creating a timeline, especially in project cases, really allows you to, maybe it's just the way my brain works, but it really allows you to absorb the disclosure and the investigation and get a real sense of what transpired when, right? And put it in
Yeah.
order in your
No, but
head.
this is, yeah, it is good advice because ultimately this is also a lot of attack on the police investigation and the way they do the work. And so you want to know what happened first, what things they did and in what order. So it is actually really good advice to have a timeline, like a table of chronological events listed chronologically.
Yeah,
Um,
absolutely. And another really big source of information for that is the investigating officer.
mhm.
Getting the investigating officer's notes and starting to go through that chronologically. They're usually quite voluminous, and that is one of the first items of disclosure that I'll look at, just to get a sense of how did this information develop? Was it CI number one, that
Yeah.
identified target number one, and then things go from there, right? So that's an important exercise.
Well, but here's the challenge though, Leo, because what you're saying, it sounds and it obviously is very time consuming. So then the issue here is how do you balance that with 11B? Because you know how the courts will always pressure us. Well, you need to have a CPT and a JPT within 6 months if we're starting in the OCJ, and then everything has to happen very quickly. But this is a lot of disclosure that you have to review. You can't just like skip it and just go and have a CPT. You really need to review all these things, but you have all these deadlines and time pressure. So how do you balance that in terms of
Well, and
11B?
I find it frustrating too,
Yeah.
because you get a lot of the crowns who are really performing concern for 11B
Right.
and asking you to have a CPT right away.
Yeah.
And it's like, well, I don't even have the ITO. So
Yeah.
what are we going to discuss at a CPT? And I got to block off time to have a CPT where we're going to say, I don't have the ITO, so let's have another CPT down the road. And this happens in a lot of project cases. And it's the same thing with JPTs, where it's like you have a JPT, but not everyone's ready. You don't have all the meaningful disclosure enough to have a JPT. So it is very tricky. I mean, I think the post Jordan era has impacted a lot of the justice system participants, as they say, and we have an obligation to be proactive and to address the culture of complacency and whatnot. So I think it's important to be on top of what you don't have. And when it comes to projects, the ITOs are very often the most important thing, because
Right.
then once you have the ITOs, the next step is, okay, how is that ITO sourced? Do I have all the underlying material? If the ITO, for example, refers to a traffic stop that was conducted in which they were able to obtain information about the accused, about your client, do you have that? Do you have the investigative action reports or the occurrence reports for that traffic stop? Um, and if not, you should request it, right? So part of being diligent on 11B is making those timely disclosure requests and not just sitting back and expecting that they're going to get back to you, right? So a good place to start in terms of being diligent on 11B, again, is the ITO. The ITO makes reference to X. You got to look through and see if you have that. Do you have the officer's notes, or do you have the IA or the RMS readout or whatever it is, right? And make that request. So I'll often just like have a draft email open where I start listing, and it ends up becoming like an omnibus
Hmm.
disclosure application, right?
Yeah.
That by the end of it has like 15 bullet points, and that could be the subject of litigation, because that's, one of the steps of the six steps of
Carefully,
Garofoli.
yeah.
And oftentimes you're litigating whether the crown is required to disclose that or not, and that there's good case law on you having the right to access those underlying materials, subject to privilege, of course. So that's a one sort of like one of the first avenues for you to be diligent on delay and making sure that the file is progressing.
Okay, so it's focus on the ITO and the underlying disclosure, like what's missing in there. And I mean, the point that you made is actually a really good point here, is that you want to identify what should be there and what's missing. Like some of the important things that are usually there in these types of cases are the ITOs and the warrants and all of that. Then you can have at least a meaningful CPT and JPT, because obviously, we know the crowns are going to say, well, you don't need to have everything you're asking for to have a CPT. You can still have a CPT, but the ITO is one item that you really need to have before you can have any meaningful discussions.
Yeah,
Um,
absolutely. And I think, sometimes too, just from experience, you learn about the existence of material that may not be explicitly referred to
mhm.
in the ITOs, like just from doing some of these cases, and not necessarily projects, but, warrant cases. I learned on a case a few years ago on dynamic entries that there's a document that drug officers use, as well as tactical unit, a separate document. It's called a SMEAC, and I don't know what the acronym is anymore, but it's
Yeah.
where they're looking at, you know, justifications for no knock entry, justifications for dynamic entry. And so they'll have information about the target and the residence itself, the layout of the residence. And it may have a lot of useful information that you may be able to use to challenge the manner of search. So, leaving aside the sufficiency of the evidence, you can still challenge the manner of search. And I mean, Ottawa has been particularly, a jurisdiction where this has been successfully challenged. The resort, almost automatic resort to dynamic entries in the last few years, and I learned about the existence of these documents, SMEAC reports, by challenging the manner of search in one case where the Crown arguably made a mistake by calling a duty inspector who's pretty high up to testify about these things. And then lo and behold, I was able to get a treasure trove of documents that I now ask for in every
Oh,
single case
wow. Yeah.
involving dynamic entry. And the same goes for the use of informants. So the handler or other adjacent officer will often, I think in every case, create something called a source debriefing report, and that involves an assessment of the reliability of the informant. And a lot of it's redacted, but it does contain information sometimes that you may find useful. For example, or even the absence of information about, like, was it first or second hand information? Have they locked down whether the informant actually received this information directly, or whether they just potentially learned about it? Or did the police verify that? So these kind of documents, I think, are very helpful. And, I learned it kind of on the job
Yeah.
through litigating cases. But I mean, I use textbooks pretty heavily. I use the Eamon series book on Section 8 and warrants, and Scott Hutchison's book as well on warrants. And I just kind of continuously educating myself on these things, and I always pick up something here and there on documents to request. That is just, I think, making those requests for those documents, and if the Crown says no, well, then that might lead to litigation, right? It's
Yeah.
the same thing with handler notes, for example. They almost never want to disclose those, or if they do, they're heavily redacted. But that doesn't mean you shouldn't ask for it,
Yeah.
right? So
Yeah.
that early process of requesting disclosure, I think, is really important in order to address 11B. You don't want to be seen sitting back.
Now, to add more to the layer of difficulty in these types of cases, Leo, is the fact that we're dealing with multiple co-counsel as well.
Yeah.
And so that also can add some delay, especially that many of these cases, there's going to be change of counsel as well. Someone is going to fire a lawyer at some point. There's going to be a breakdown. And how do we coordinate here? Like, what do you do? What is your advice for these types of cases? Should you actually communicate with co-counsel, or should you just focus on your client and yourself and just disregard what's going on, what the others are doing?
Right. Well, one of the first things I want to do is I want to know where am I
Hmm.
in the sort of pecking order of exposure to criminal liability. Like, where is my client? Is my
Yeah.
client kind of a lower level, alleged to be a lower level person, or are they like the target? You
Yeah.
know, and there's always, especially involving a lot of co-accused, there's always some co-accused that just want to get a plea in
Yeah.
and get sentenced, and
Yeah.
that might be your client.
Yeah.
In which case, either way, I think it's important for you to identify fairly early on, like what is the strength of the Crown's case, and I get that that's impossible to determine in a perfect, in perfect with perfect information early on, but you do want to get a sense of your client's level of exposure and their appetite for resolution.
Hmm.
A lot of that depends on whether they're in or out of custody, of course. And so you have that to worry about as if you don't have enough to worry
Yeah.
about. But getting a client out on bail in a project, they come
It's
at you
hard.
hard
Yeah.
on
Yeah.
detaining your client. But I like to meet with counsel for co-accused early on, and just to get a sense of who's trying to resolve and who is out there trying to get bail, and who is out there wanting to go basically fight until the bitter end and go for prelim and superior court, right? You rarely see juries, at least in my experience, you rarely see juries in these kind of cases, although I know in other jurisdictions people are more apt to elect judge and jury. So, but I do always have sort of in the back of my mind, are my co-accused going to take me to Superior Court? Are they going to
Yeah.
take me into a prelim, or are we going to stay in the Ontario Court of Justice? But I do
Well,
want to have that meeting fairly early on to get a sense of where everyone's at.
but let's talk about that because that's an important issue, the election and how you want to proceed. I mean, you're dealing with multiple co-accused, and not everybody's going to be on the same page or is going to want to do the same thing. So, how do you resolve this? Like, let's say someone wants to stay in the OCJ, not interested in having a prelim, wants to go to trial, but not the same strategy. So, what happens here?
Yeah, well,
What do you
very
do?
often your choice will be made for you by the Crown preferring the indictment.
Mhm,
I
yeah.
find that
That too. Yeah.
that's become fashionable in the
Yeah.
last few years.
Yeah.
And again, I don't know about other jurisdictions, but I do know in Ottawa, on project cases, the Crown will more often prefer the indictment, which lands you in Superior Court.
Hmm.
And
Without a
so,
prelim. Yeah.
yeah, without a prelim, if you, especially if you have kind of counsel peppering the record, saying, "Well, I want a trial in OCJ, and I'm going for severance." The Crown will often use that significant power that they have to prefer an indictment in order to, I think, address the 11B that they fear is going to come down the road.
Yeah.
So then you end up in Superior Court. But I think your choice of OCJ versus SCJ largely depends on your assessment of the bench. And regardless of whether you want a preliminary inquiry or not, I think each council is different in terms of Superior Court versus provincial court, depending on jurisdiction. You have to know your bench and know the roster of judges there, and be able to advise your client and have them choose. Obviously, it's their choice, but that's going to be informed by you. And so, I think a large part of it is your level of comfort with the bench in Ontario Court of Justice versus the Superior Court.
And what if, let's say, in a situation where we're left with co-accused who want to go to trial, but the disagreement here is, like OC, like putting aside, let's say the Crown is not using their power and did not prefer the indictment, and you still have a choice of whether it's going to be OCJ and SCJ. So how do you coordinate in that time when there is conflict, when there are contradictions between
Yeah.
co-counsel? It must be a
Unfortunately, the
headache. It
lawyer,
must be a headache.
it is a headache because
Yeah,
unfortunately the lawyer that wants Superior Court judge and jury
yeah,
wins by default,
yeah.
or they have the trump card. No matter what anyone else says, if there's one lawyer that wants judge and jury Superior Court, that's where everyone's headed, unless you're asking for severance. And so then you have to go down that road of looking at severance as a
And
viable.
how successful is that in these types of cases?
I mean, it can be successful now because of Jordan, because the Crown is concerned about charges being stayed. But again, I know your hypothetical involves no preferring of the indictment, but I think
Yeah,
the Crown usually will opt to prefer the indictment over consenting to severance, like almost,
yeah,
6 out of 7 times.
yeah.
So but it is something that I think you have to do as counsel is say if you want your trial in the Ontario court or if you want judge alone, you have to be prepared to make admissions perhaps that is going to shorten the trial so that you can justify severance, be able to set aside time earlier in your schedule so that you can say, I'm available much earlier. I know in Ottawa, for example, I don't know about other jurisdictions, but they don't set jury trials in the summer. I don't know how this practice has survived post Jordan, but they do not set jury trials in the summer. And so I often say, well, I'm available in July.
Yeah.
How about we all sit in a windowless courtroom for several
Yeah.
weeks in July? So you have to be prepared to do that, if you want to protect your client's interests.
All right. So now then the other issue in these cases, Leo, is charter issues because I don't think it's possible to have a project case and not have charter litigation. Um, but of course, here, not everybody's going to be involved. Everybody, I mean, not every accused is going to have their rights violated in the same way. Some of them may have charter issues, others not. And then there's the whole issue of standing. Um, how do we structure all these
Right.
charter challenges in these types of cases?
So it's like warrants are complicated.
Yeah.
The law
Yeah.
on challenging warrants is very complicated, if not, among the most complicated of
Yeah.
charter issues. And so even as someone who has done a number of these kinds of challenges, I always feel like I have to go back to square one and review the case law. Standing is obviously your first area of concern.
Hmm.
If your client's name doesn't show up until ITO number 6, do you have standing to challenge ITOs 1 to 5? I mean, there's case law that says that you don't. But if the other co-accused who is named in 1 to 5 is going to challenge that, then you might want to talk to the Crown about what, if any, impact that might have on your client. I've had cases where the Crown has agreed that if the co-accused succeeds in that challenge and it leads to exclusion of evidence against their client, that against the co-accused, then the Crown would potentially agree to exclusion of evidence against your client. I've had that happen. Um, but you should look at, where does your standing come from? Where does your client's name first come up in the ITO? And look at what got the police to that stage of the investigation. Um, I find oftentimes an overlooked area of warrant challenges is the grounds to believe that evidence of the offense will be found at that particular place. So in projects, you often have the execution of warrants at like 8 different addresses, and your client's at one address and there's other people
Yeah.
at other addresses, but you have to look at the surveillance and the other evidence that's tying the alleged activity to that particular address where your client was found. So they might have ample grounds to believe that criminal offenses have been committed, but what are the grounds for them to believe that that address where your client is found was the stash house, right? If they
Yeah.
have one singular observation and it's kind of vague, is there impermissible opinion evidence given that can be excised or at least read down in the ITO that might lead to insufficient grounds to believe that evidence will be found at that particular address? I think you need to hone in on that sometimes. I feel like that's often overlooked. Um, I'm a big fan of the subfacial challenge. I find, the case law on leave to cross-examine is very unhelpful to the defense. I find it very frustrating, in fact, that this whole body of case law has developed to avoid using up court time, that to cross-examine affiants, and the presumptive reasonableness of the warrant is in favor of the Crown.
Hmm.
Meanwhile, you spend all this time litigating whether you can cross-examine the affiant. But there is, you know, irrefutable case law to suggest that you can do a subfacial challenge without cross-examining the affiant. You can simply rely on a paper record to say, well, the ITO says this, but the surveillance report in the disclosure actually doesn't say that. And so the ITO, that particular observation as characterized in the ITO, should be excised. And that is effectively a subfacial challenge that's done without seeking leave to cross-examine the affiant. So, I'm a fan of doing those things, but it does require pretty diligent review of the disclosure and, again, the source material that the
Yeah.
ITO relies on in order to sort of cross the I's and or cross the T's and dot the I's.
All right. Um, But then, so after the charter issues, there's also the actual trial. So in the cases, well, two things that I want to talk to you about the deals that because I guess these are also cases where the Crown would want to resolve for at least some of the people and
Yeah.
some of the accused, and just focus on the main targets of the investigation. Um, for the deal here, what can you do to secure a good deal if, let's say, your client wants to resolve?
Get
Because
your client
sometimes,
out on bail.
yeah, well, okay, yeah,
Get your client
no,
out on bail and have them, try to have them working or doing something, with their
yeah,
time. I mean, obviously, that's easier said than done when you have a tendency, especially on projects, for people to be released on the strictest of conditions, like house arrest, that wouldn't allow them to work, right? But oftentimes, even if it's strict house arrest at the outset, compliance for several months might lead to a relaxing of the conditions, and if they can get some form of employment, oftentimes that'll help you, right? If your client is one of the, alleged to be lower level involved people,
yeah,
the Crown's not going to be really focusing on them, and you can go for that, that precious CSO if it's available to you.
yeah,
Usually the Crown won't agree to it, but it's something you can fight for, and if your client's racialized, get an enhanced pre-sentence report. I find them, tremendously useful, and often, and more often than not, they're very, very well written. So you have to have a bit of the stars aligning in terms of getting your client out on bail, them not being as high level involved, according to the Crown's allegation, and being able to get those bail conditions relaxed somewhat so that they can pursue some, what's referred to as pro-social activities.
yeah. Well, I mean, the challenge in sentencing in these cases, it's the range, right? Like
Yes.
the range is pretty brutal for these cases because sometimes it
Yeah.
starts at 5 years.
Yeah.
You can't go lower than that. Obviously, a judge always has discretion, but sometimes it's kind of impossible because it depends also on the amount that's at stake, if there's weapons also involved in all of that. And um, so. What's a bit, if we want to talk a little bit about the relationship with the client in these cases, because the clients can also be a little bit more difficult
Yeah.
for these types of cases. So if you want to go resolution, but you're dealing with a case, your client is stuck with a pretty bad range. Um, what can you do here if you want to avoid a breakdown
Right.
and getting off the
So what I
record?
would say, first of all, it's unfortunate that we seem to have, I mean, the justice system seem to have forgotten about the usefulness of prelims. But I think one of
Yeah.
the positive aspects of a preliminary inquiry is for your client to be able to see how things play out in court
Hmm.
before trial, and that can often lead them to being more resolution oriented because they may not have a realistic understanding of the case against them.
Yeah.
But then if they hear the intercepts being played or the observations of the surveillance officer being testified about in court, then they might slowly come to the realization that they should be perhaps a little bit more resolution oriented. So I do find preliminary inquiries useful for that purpose. The other thing I would say about ranges is, ranges are ranges, but they're not straitjackets, as the
Yeah.
Supreme Court has said. And
Yeah.
there was an excellent presentation done recently by Chris Rudnicki, and I'm sorry to say I forget the name of his colleague that did the presentation with him, but it's all about using the case law to get under the range. A case called Friesen, we're all familiar with, and Perrin.
Yeah.
So these are cases where the court talks about the range, but then there's some really good language in there about how ranges are just a guide.
Guidelines.
They're
Yeah.
not a straitjacket,
Yeah.
and that sentencing judges should have the ability to be flexible, and sentencing is an individualized process, et
Yeah.
cetera, et cetera. So I think you should have those cases handy as well, and try to highlight some of the exceptional factors that your client has in their favor, and oftentimes where your client is racialized or indigenous, an EPSR or GLADU report, I think will really help with that.
Yeah. So, and you are a proponent of enhanced pre-sentence reports, right?
Oh
So
yeah,
you
absolutely. I
okay.
think unfortunately there's a lot of delays in
Yeah.
getting them because I think that the sentencing and parole project out of Toronto that does, I think, all of them, if not most of them, it's just backlogged, right? So they take like 6 to 9 months. If your client's in custody, that's obviously a huge problem.
Yeah.
Um, and also for a client that's privately retaining you, they cost a lot of money.
Yeah.
They're I think around like $6,500 or something
Yeah.
like that at this point. So, but I am a huge proponent of them. They're very well written. They're very well sourced. They're not, it's not like they're done by probation officers. Not to knock probation officers, but these are lawyers that are dedicated to the cause of enhanced pre-sentence reports, and of assisting marginalized or vulnerable groups that are overrepresented in the criminal justice system. And so I think that dedication is really comes through in the reports that they write.
So the last area that I want to cover with you, Leo, is we talked about sentencing, but in if the matter doesn't resolve, at least for your client, it doesn't, and for another few, and it does end up going to trial. So can we talk a little bit about the trials for these types of cases? Because they're probably going to be very long, several weeks. They're intense, and there's just a lot of litigation going on here. So just tell us a little bit about the trials
Yeah, and
for
I
these
think
cases.
that's where also it's important to communicate with counsel for co-accused as well.
Hmm.
Division of labor is always good. Well, I shouldn't say it's always good. It's often good, a division of labor, but when you're talking about defense lawyers, you're talking about a lot of egos in the room and a lot of
Yeah.
control freaks, right? So you have to come to some sort of agreement about who's going to take the lead on what, avoid duplication.
Hmm.
The court's going to be even more sensitive to delays and the trial finishing in time when you have multiple lawyers. And so on top of that, they're going to be cutting off your cross examination if the lawyer that just went before you has already gone over that stuff, right? So it is important to coordinate with other lawyers. Um, you know, Personally, and this might say a lot more about me, I like to be the lead. If my client's higher up and is directly implicated, I like to take the lead. I don't like to sit back and rely on other lawyers to do the work for me. I like to take the lead on the submissions. I might discuss with other counsel. Okay, like preparing the materials. Can someone take a first run at the drafting of the materials, and then we'll sort of coordinate, get a Google Doc going where we can all kind of contribute to the work product. Personally, I'm not a huge fan of writing. There might be some appeal lawyers that, or people who moonlight as appeal lawyers, that might be better at writing the material, whereas I'd rather go into court and argue it. So a division of labor of the writing versus the arguing when it comes to charter applications is important. If you're blessed with having other lawyers that are really good, you can learn a lot, right?
Yeah.
Even as this, if you're a senior counsel, you still learn a lot because there's a thousand ways to skin a cat. Like there's so many
Mhm.
different ways you can approach a file in a charter argument. Like you never stop learning on the job. So I think it is important to just have open lines of communication with other counsel, those of us that are dedicated to actually fighting the case as opposed to resolving if you're at the trial stage. So, communication is key there.
Okay. And how is the relationship here with the police and the crowns? Now, for these types of cases, though, the police are usually more experienced. Like these, we're talking here about police officers who are seasoned police officers who should be
Yeah.
putting aside the Toronto, like the Project South, what's going on right now. But let's say we're in a normal world where we're dealing with police officers. They're usually very experienced police officers who they do this all the time. So they know what they're doing. Um,
Yeah, you're usually dealing with experienced
yeah.
drug unit
Yeah.
officers or major crimes.
Hmm.
There's a certain level of I think professionalism there. That doesn't mean that they might see the world in a completely different
Yeah.
light that would allow you to maybe exploit some of their assumptions that they make or some of the conclusions that they jump to. But there is a level of professionalism that you don't see as much with the sort of the street level
Yeah.
police officers.
And the crowns, do they usually, what if we're dealing with a case where there's, let's say, more than one crown?
Well, you almost always have more than one crown in
Yeah.
project cases. I find
Yeah.
you have at least two, sometimes more crowns. Usually they're federal crowns. And I mean, every crown's office is different, right? So um, I feel like in Ottawa, and I can speak for myself as well as I guess anecdotally what I see with other defense counsel in this jurisdiction, we have a pretty good working relationship with the federal crown. Sometimes things can get heated in court, but usually things are kept very cordial outside of court.
Yeah.
And I find the federal crown's office, unfortunately, they have a lot of former defense
I
counsel that I used to be a
know.
lot closer with than now. So it is a bit of a sting having to litigate against former defense
Yeah.
counsel, but the relationship is usually a good one.
Yeah. And that's true. I can confirm that we do have a pretty good federal office, I find, in Ottawa, and I find they're very reasonable as well. You can work out a good deal, especially if your client is not really that much involved or has a good explanation for why they were there and why they were involved. I find it's a good opportunity also to try to negotiate with them.
Yeah, I tend to agree with that. Yeah.
Yeah. So, Leo, is there anything else, final tips that you have for these types of cases? Especially, I would say for someone who, like new lawyers who are dealing with these cases for the first time, just some final thoughts and tips that you can give.
Yeah, I mean, I think if you're a new lawyer
Hmm.
and you've got a project case where you have a person that's not marginally involved, don't be afraid to ask or even to pull in a co-counsel with you to help. I realize that resources can be limited. You may have a client on a limited retainer, but it's sometimes worth asking for counsel's advice if you have um, a legal aid certificate. There are opportunities there for you to get co-counsel as a mentorship opportunity. I think not enough people sort of avail themselves of that opportunity to get co-counsel approved on a project case because it could even be a big case management file where you can justify getting a budget
Yeah.
or co-counsel. And so I find it on big cases, and this goes not just for projects, but also like homicide cases or cases that are just complex. I don't like doing them alone,
Hmm.
and I don't think if you're a junior counsel that you should have to do it alone either. So that would be my main point of advice is to try to get, if you can't get co-counsel, get at least somebody that you can bounce ideas off of or help you with sort of navigating some of the issues.
Yeah, no, that's really good advice, especially for new lawyers. And it is important because it actually can be a really good learning opportunity because of all the other lawyers who can be involved. And usually there are really good lawyers who are involved in these types of cases. So
Yeah.
it's really good for new lawyers to learn. It's a great opportunity to learn. And Leo, if people want to reach out to you, where can they find you?
Well, usually at the courthouse, you can find me, but
Yeah.
also you can email me. I'm at leo at rh-lawyers.ca. So yeah, feel free to reach out. Always happy
All
to
right.
talk to other members of the defense bar.
Thank you so much, Leo, for your time today and for sharing your knowledge and expertise about these project cases. And I hope to have you as a guest again, and we'll talk about something else in the
Anytime,
future.
Maya. Thank you.
Thank you very much.
Okay, take care.